Recording stopped. Close this out, swipe this down, swipe this over, and record. 3, 2, 1. And we're back live. This is video 5 of 11.
That was hers. Let's do his. I freed up some space. I had to move a couple of things around and freed up some more space so I can continue on my venture here. I'm going to try to read these a little bit faster. Now comes the defendant, nameless, by through undesigned counsel, nameless, respectfully moves this court in the following orders. Designated defendant as the legal custodian of her minor child. It's not her minor child. It's no way ever been any shape, form, or part of her minor child. Never. I picked his name 10 years before he was born, just like I did his sister. They have my last name. I've had custody of him since he was 5 months old, just like I have her since she was 7 months old. The designated defendant as the legal custodian of her minor child until further order of the court. Review existing child support. Well, yeah, because you don't pay any child support. You never have in neither of their lives. I've provided everything for them myself. Just me and what I get alone, I've taken care of them myself alone. Any other court orders, the court deems necessary and appropriate for cause. The defendant asserts, is her in the best interest of the minor to be in her custody, and those reasons will be set forth more fully at the hearing above in the captioned manner. Motion filed. Now comes the defendant. I'm the biological and legal mother of this boy. Plaintiff, my name, is the biological and legal father of the minor child. I'm the full custodial parent of him. I have been the full custodial parent of her and both of them since each of them was roughly 6 months old. When I paid my money for my DNA test, that I already knew I was the father, I didn't do it to prove that I was or wasn't for myself. I did it to prove that I was for the government. And though I could have spent $1 through Jobs and Family Services and done it for $1, I didn't do that. I paid, it was either $200 or $399 for hers, and $399 or $499 for his, because it was $100 more the second time. I don't think it was $299, $399. It was $399 or $499. Either way, I paid all the hundreds of dollars myself when I could have done it for $2, $1 for each of them. I did it myself, for myself, so that I could show later whose they are. And with the DNA testing for each of them that I included in the reports that you signed in this stack of papers when you signed your rights away in this stack of papers here that is almost 7 years thick now. Honor is in the current legal custody of the plaintiff. I resided with the plaintiff and our minor children until approximately October 17, at which time the plaintiff kicked me out of the home. The plaintiff and I reconciled again. He kicked me out of the home in December of 2018. I have not seen the minor children since that time. It is not safe for either of the minor children to be in the legal custody of the plaintiff. Again,
So, just the same. One, she left out coming back December 25th, Christmas morning, 2017, and she left leaving January 19th, 2018. She left out the second time, which, like I just showed, I have a note for. I have the note that she wrote when she left. She wrote it January 2nd. I woke up to it January 3rd. There's 2 videos recorded of it published on YouTube a year or 2 ago, or 2 or 3 at this point, I don't know. But either way, just the same.
this was unsafe.
If the children was unsafe in 2017, why is it 4 years later that you're just now filing the fact that they are so unsafe and I am such a danger? If these children, my children, were in danger being with me, their father, why did you wait 4 years to have this in a courtroom in front of a judge or any potential person that could possibly correct my dangerous self or help the safety that they needed? Why did you never give them more safety from another person or remove me as a danger as I'm a danger to them? Why did you wait 4 years? You think waiting 4 years to file this paperwork really shows any danger? Does it really show that there's a safety issue with them being with me if you waited 4 years to file it? Right.
The latter months of 2017, then why is this only being brought to the court's attention in the beginning months of 2021? 2018, 2019, and 2020. 3 years. They're in such danger that it's taken 3 years for you to decide that you want to do this now? That's not protecting any children.
Also, like I said, when she was here in 2017, there was no danger. There was no safety issue. When she left on Halloween, there was a safety issue and the children were in danger. When she came back on Christmas, 2 days later when she collected the money from Attorney Reed, there was no danger and there was no safety issue. When she left on January 19th, 2018, and by the time June 21st came, I got court papers again. Now there's danger again and there's a safety issue again. Then she drops the case in October of 2018. So in November, I let her come back as girl, November 10th, 2018. And 39 days. So when she came back, there was no danger. There was no issue. There was no safety issue. There was no problem. Then she leaves again 39 days later, December 18th, 2018. And then after 2019, 2020, and now it's 2021, 3 years later, oh, there's danger. I'm not with him anymore. Now there's danger again. There's a safety issue. Because I'm not with him. Now there's a safety issue again. Come on, man. Anybody can see that she's doing this over relationship issues of a relationship existing. There's no danger. Relationship not existing. Oh, there's danger again. Oh, the relationship exists again. There's no safety issue. Oh, the relationship is ended again. Now there's a safety issue again. 3 years later. Okay. Anybody can see what the truth is. Okay? Anybody can see what the truth is there. That's right.
If they was in any danger, you wouldn't have dismissed the case last time when you were afraid of going to prison for lying. You would have went through with it. If they were in any danger, then you would have never came back and reconciled or tried to. You would have filed the paperwork the first time when you hired Nikki Reed and obtained her and gave this affidavit the first of 3 times. you would have never had her not file the paperwork like you had her not file it the first time because you knew that it was full of lies and you were going to get busted. Remember? And you forgot that when it came to the second time. And then you were reminded. And it's been a couple of years, and so I'm curious, like, did you forget that you were going to go to prison because you purged your affidavit?
Which brings me to my other good point. Like I said, this case needs dismissed with prejudice just on the grounds alone that it's already been satisfied twice. She obtained Attorney Reed, gave her the affidavits, paid her the $2,000, and then collected $1912 as she only spent $88 before she filed it, as these complaints were satisfied. And then just the same, after she left again, and then she filed again, as we weren't together again, is what I just said. Now there's no relationship, so now there's a problem again. She filed it, I got the papers in June, went to court in July, went to court in September. It was dismissed again in October. For the second time, she dismissed this case as these complaints were satisfied. She came back in November, left again in December for the third time, and so now after 2 years of no contact, never reaching out, not asking about the kids, not asking to see the kids, not asking one question about the kids in 2 years' time, and then now all of a sudden for the third time, I have the same perjured affidavit, and for the second time, I'm in the same courtroom facing the same affidavits that was the first set of affidavits from 2017. This information is 4 years old. And finally, after 4 years, after you've been satisfied, 2 times this case was satisfied. You filed the same paperwork as it's not satisfied after you showed the court that it was satisfied last time. 2 times in reality, but in court once you've already showed them these claims have been satisfied to you. Now you refiled the same claims again, as in now you're unsatisfied again? Really?
Plaintiff is mentally unstable. He has a very bad temper. Well, you know what? That reminds me of something. I was the one that caught you in the bathroom at my mother's house before we moved into this house with a butcher knife ready to slit your wrist. I pulled the knife out of your hand. I called the suicide prevention place. I took you to inpatient care as you was there for a week. I took care of our daughter and our infant son for the whole time that you were inpatient and visited you so that you didn't go wacky loony nuts. There's record and documentation of that, too. Both children... Oh, wait. I have witnessed the plaintiff scream in the face of honor when he was 4 months old. Both children appear to be afraid of the plaintiff. Plaintiff frequently calls them both names such as Little Mother Effers. Well, I can tell you one thing. If it's anybody that's been documented, that's mistreating any of the children in any way, that's abuse, it's you. It's called abuse by neglect. And you have neglect of these children. You are not fit to be a mother. You have admitted on videotape, woman, that you're not fit. You cried tears saying that it's not your fault, that your mother didn't teach you how, but that you don't have the skills. And yes, that makes you sad. It makes you feel like an absolute horrible person. But filing this affidavit as lies and purging yourself doesn't make you fit. It makes you further unfit, mentally unstable. If you are telling your attorney that I'm telling them you're dead, and your attorney filed this paperwork in a highly prejudiced, egregious highly egregious manner, what does anybody think you're going to tell the children? If you're manipulating the court system saying that I'm saying that you're dead, what does a counselor or a therapist or CPS or social worker? What does anybody else think you're going to tell the children in private? The obvious, most worst, horrible lies you could even imagine. She said they're going to attempt to destroy these children and the hard work that I've done in healing their hearts and broken minds. Again, plaintiff has been physically violent with me. He whipped me with the belt. He spanks honor more frequently than he spanks freedom. Okay, well, let me tell you something about spankings. The last time that I whooped my son was over a year ago. Over a year ago. The last time I whooped him, he had a plastic track, car track, Hot Wheels, and he hit Freedom in the eye with it. That was the last time that I whooped him. That was over a year ago. And the last time I whooped her, I can't even remember if it was 2 or 3 years ago. It's been so long. It's been 2 or 3 years since I whooped her. As I say, you know nothing. You don't know me. You don't know them. You don't know us. They don't know you. I know everything. But I've also documented everything. And I can prove and show the truth to anybody, everybody. Plaintiff does not care for the medical and dental needs of the children of the minor had bottle rot. Yes, he did. And the dentist that performed his surgery that I took him to, that you dipped out a month or 2 before, said, clearly this is nothing that has happened in the past 6 months from October until now. This has happened as a matter of years. We can see the decay on the teeth. We know the age of the decay on the teeth. It's 2 and 3 years old. It's somewhere roughly around 2.5 years. You would have been here giving them Kool-Aid at that point. I told you the Kool-Aid man doesn't have any teeth for a reason, because it'd be false advertisement. Plaintiff has told me he will not take him to the dentist because they put mind-controlled chips in people's mouths. Plaintiff did not take the dentist to the children until Stark County Jobs Department of Family Services got involved with the family in 2018. Again, that is a lie. She's painting a pic.
Again, the first time I took her to the dentist was December of 2017. Heather wasn't here because she abandoned him the first time then. It was before she came back on Christmas. The second time that I took her to the dentist was in January of 2018, which was before she left January 19th, and she was here. One of the times that I took her in January of 2019. So to make that claim that CPS had to get involved for me to take them to the dentist is totally bogus, because it never happened. And a further point, in this affidavit, she says that she contacted CPS and tried to have a case opened against me and to try to expose whatever that I was doing wrongly to or for or against the children. But CPS just would never do anything about it. They never opened a case. They never got involved. So in one sentence, she tried to contact CPS. The CPS just wouldn't do anything. In the next sentence, the only reason I did anything is because CPS made me. So in one sentence, CPS did get involved and forced me to take her to the dentist, which actually didn't happen. And in the next sentence, CPS just wouldn't listen to her, wouldn't get involved, and wouldn't open a case, which actually did happen. They came here, they expected the kids, they said there's no cause for case. So what I'm saying is, you can't have it one way, they won't get involved, and the other way, I only did an action because they got involved. Because both of them can't be true. Just being a very dishonest person, also not being very intelligent. To include, one time, I tried to get them involved, but they just won't get involved. And then another time, the only reason he did this is because they got involved. Well, how was the only reason I did that because they got involved, when in fact you just say they didn't get involved? One time they're involved, one time they're not. One time they're not, then they are. One time I only did it because they got involved, and the next time they wouldn't get involved if you asked them. And one time, they wouldn't get involved even though you asked them. And then the next sentence, the only reason I did that is because they got involved. Well, which one is it, lady? Which lie is it? Can't be both lies. Pick which lie and stick with it.
For me to look crazy, like I'm insane, when the fact is, Jobs and Family Services has never been involved in my children's lives. Ever. For the sense they came here once, inspected my children, said there is no cause for case, and left. That was the extent of CPS, Child Protective Services, any social worker, whatever, whoever, whatever. Anybody at Jobs and Family Services or any government official or whatever. The extent of them being involved in my children's lives was stepping at the threshold of my back door, inspecting my children with their physical eyeballs and saying, I'm satisfied. They're safe. They're healthy. There's no cause for concern here. And it's on videotape. I have everything on tape. I've been nothing but protecting my children since the day they were born. For an attorney to file this paperwork, never investigating a piece, never researching a shred, never having a shred of evidence, never having a piece of any part of proof that any of these words are true, is highly prejudicial and highly egregious. Period. Exclamation stamp. The plaintiff was told to take honor-to-speech therapy by a doctor, and he did not. Until Stark County Jobs and Family Services got involved with the family in 2018. Again, that is not true. That is not true. There was never been any involvement from Jobs and Family Services, and in fact, on another part of this paper back here in one of your other affidavits, because you have your income and expenses affidavit, it's not filled out, and many places left blank and empty, which is not supposed to be that way. It's not fully filled out. You even said, oh no, it was up here already in the motion to in the affidavit of defendant. You had said that you had tried to get Jobs and Family Services involved, but they wouldn't. Oh, okay, so I'm not even at that part yet. Okay, that's my fault. So again, if you're an attorney and it's your job to protect children, and part of protecting children is obviously doing your job, filing these papers, to look out for the best interest of the children, not the mother, not the father, the children, not your client, not the liar, your children, the children. I find it highly egregious and highly prejudiced that you would be so unaccountable and so irresponsible to file this paperwork with any court without having a shred of evidence or any piece of proof whatsoever. That is not a responsible thing to do for any attorney, let alone ones that is supposed to be looking out for the best interest of children, providing protection for them. That is about as corrupt gets. Now, if you had no idea of any of this, you do now. If you had no idea that this was the case, you do now. You have a responsibility to drop your client and dismiss this case with prejudice. Even if it was accidentally, initially, at this point, afterwards, it would be on purpose.
So I'm at 2424 on this one and 2353 on the other. So I'm stopping this one now.